Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Hello, everyone, and welcome back to another episode of International Law Behind the Headlines. I'm Cal Raustiala, and I'm really happy to have on the podcast for this episode two colleagues and friends that I've known for quite a while and really respect their work, and I think they'll be familiar to many of you. So Katerina Linos is the Heyman Professor of Law and co-director of the Miller Institute for Global Challenges in the Law at UC Berkeley, the law school at UC Berkeley. And Mark Pollack is the Freeney Professor, I hope I'm pronouncing that right, of Political Science and Law at Temple University. And together, Katerina and Mark have been working on a project for, I guess, about a year now, a little over a year, looking at the judges in the European court system, the Court of Justice of the EU, and interviewing something like 2/3 of the justices or judges on that court. And they have been compiling those interviews, talking about them. Katerina has a podcast of her own run out of Berkeley called Borderlines that goes in greater depth. So if you want to go deeper, you can go to that. And on this episode of the ASIL pod, I really just want to get into what the project is about, what are some of the interesting things they've learned, and dive a little bit into what's come out of these interviews. So Katerina and Mark, welcome.
Thank you.
Good to have you both. So I guess the first thing that we can start with is maybe just a little bit of background about the court. So, I think many listeners are familiar with the idea that the EU system is a kind of system of treaties and to some degree of international law. I guess that's somewhat of a debated question as time goes on, how we might characterize the broader EU project. But certainly the courts within the EU system are so active. So I think many of the listeners are probably broadly familiar, but tell us a little bit about how you define the project, what the court's ambit is, and why this court. Why is this court important for international lawyers to understand?
Thanks so much, Cal, for having us on the podcast. This is Europe's most important court. It has judges from the 27 member states. These are officials who have often held senior positions in their national judiciaries, and then they go to Luxembourg. The project of European integration now includes all kinds of topics that were previously domestic law and that impact not only European citizens, but also all Americans and international lawyers. I'll mention 3 cases that might be significant for an American international law audience, and I'm happy to go in more detail. So I'll mention first the right to be forgotten case. This is a Google case. It is a case on which this right was created by this court and then impacted all of the privacy standards we have on the internet. I'll also mention the Acmea case. This is a 2018 case that all investment arbitrators are quite upset by because in a fell swoop, this court canceled intra-EU investment arbitration as a system. I'll also mention a 2024 case. This is a case in which the European Court forced Ireland to collect 14 billion in taxes, and in so doing, further negotiations on a global level on what the minimum corporate tax should be.
Okay, so those are three quite significant cases with connections to many other areas of international law and obviously many other countries outside the EU. So that's really helpful. So for either of you, really feel free to jump in as you wish on this, but for either of you, how did you get started interviewing judges? What made you want to interview them? And just, I guess, say a little bit about your sort of methodology or approach to this. What is the goal, and how does interviewing kind of realize that goal?
So I had the
Go ahead, Katerina.
I had the privilege of interviewing the outgoing president of the International Court of Justice, Joan Donoghue, and then the then current president of the International Criminal Court, Piotr Hofmansky, for borderlines. And I figured out that you can learn a lot about a court from the men and women who sit on it. Cal, you said that we don't know the names of the judges on this important European court. And that's true not only for American international lawyers, but often for many Europeans who no longer do EU law as a field. It's so broad and so significant that it's like knowing federal law. There's just too much of it. So by going to the judges and asking them some questions about their background, asking them to identify the most significant recent case they've worked on, we can make this very significant court much more accessible to ordinary people as well as to lawyers in adjacent fields.
Great.
I'll jump in here and say that I'm a longtime EU person and have always been interested in the EU and the Court of Justice. But I actually first started interviewing ECJ judges back in 2017 when Jeff Donoff and I were doing a project on comparative judicial dissent, why judges at some international courts dissent quite frequently, like at the ICJ, and why some never dissent, which is the case for the Court of Justice of the EU. So I spent some time in Luxembourg interviewing judges on this very narrow, specific topic, off the record, not for a podcast. And then it turns out that I'm a listener to Katerina's Borderlines podcast, and she had interviewed, as he was flying through town, through Berkeley, Judge von Danwitz. And I said to Katerina, hey, that was a great interview. You should do more interviews with members of the Court of Justice. And over coffee, we came up with this project idea and wrote to President Leonards, the president of the Court of Justice, and proposed it. And he said yes. And so we had a really terrific experience. Obviously, I would say, having done off the record and on the record interviews, the judges are a little bit more candid off the record, but we were surprised how candid they were and how interesting the interviews were.
Great. And just to clarify, I am an EU kind of ignoramus and don't know the names of judges, so forth. I'm sure many of our listeners are familiar with that, but I do think a lot of public international lawyers generally followed the path, I think, Katerina, that you just alluded to, which is certainly true for me, which is I was more aware of the EU system and the judicial system within it in the past. And as time has gone on, the system has gotten more, one might say, complex, convoluted, depending on your viewpoint. Certainly the EU itself is so much more complex. There's so much there. There's so many cases. At a certain point, you can't keep up. And I think that's exactly what you were saying. It becomes its own field, and it is its own field in many respects. But I think it has a lot of interesting things still to say to the broader field of public international law, which is why I liked the idea of having you both come on. So this sounds great. So I guess I want to get into some of the things that you learned. But did you go into this project with so Mark, you were alluding to another project where you had a sort of specific question or possibly even a kind of hypothesis about it. In this case, was this purely an inductive exercise where you just wanted to, glean as much as you could from the various interviews? Did you have a theory that you were, testing or exploring? What was sort of behind this, other than trying to get a deeper dive into the workings of the court?
So I'll answer this. We didn't have a theory. We had a format. So every interview starts with some background questions where we ask about a judge's biography. And one of the fascinating things we discovered is that a lot of these judges were integral to the process of accession of their country. They picked up EU law at a time when membership of their country was science fiction. So we learn a lot about accession negotiations. Then we ask the judges to speak about a recent case, again, to cut through the high volume of cases. The court hears 800 cases in its largest formation and has just moved a series of cases to lower courts. And having a judge identify what they think is very significant speaks to how they want to present themselves and also helps identify doctrinal questions that are not reached in the opinion, but that the judges discussed. We conclude every interview with open-ended questions about future challenges to international law, to Europe, to European integration. And again, we see some common themes there. A lot of people chose to speak about Hungary, about the rule of law, about decisions the court had made vis-a-vis this member state. So we came in without a clear hypothesis, but we are coming out with a lot of information that can help inform research questions on a broad range of topics.
Great. It sounds like a really fantastic project. So let's get into some of the things that you have gleaned from this. And maybe we could just start with what international lawyers sort of need to know about this court. So what would you say, you can list 2, 3, 4, whatever you think are, some of the critical insights about the court generally that lawyers should know that maybe we don't. And then we could dig a little deeper into some of the kind of specific things you might learn from these interviews versus simply reading cases. So what do we get from judges? But let's just start with some of the key things that you think international lawyers should know.
So I'll start with the volume of primary and secondary law that has broad extraterritorial reach. So when Brexit happened, the Brexiteers complained that over half of our legislation comes from Brussels. And that number, if anything, is an underestimate. For a lot of issue areas, this is the highest court where American firms can challenge regulatory decisions that they dislike. Let me give you the example of technology regulation. The GDPR, an EU rule that has us click through a lot of boxes, is something some listeners may have previously faced. But right now, the EU has 3 comprehensive statutes, the Artificial Intelligence Act, the Digital Services Act, and the Digital Markets Act, all of which pose very stringent regulations on the internet. The court is anticipating a lot of cases and have already heard its first cases. And the tech industry is primarily fighting battles with European regulators before a court that is quite friendly to European regulators. So I think for some specific issue areas, this is the most active, activist, and significant court.
Yeah, that makes a lot of sense. I mean, especially with technology. I mean, that's something, our friend and colleague Anna Bradford, her recent book obviously digs into this specific issue about European tech regulation. And this is a really important, it's maybe an exemplar of a larger approach of the EU as kind of the regulatory body for the world in many respects. And the court does seem super significant for that. In thinking about some of these, whether it's this particular issue or really any issue, I mean, one thing I'm just curious about is how this court, the European court, differs from, let's say, the ICJ in the way it might interpret treaties. Obviously, it's dealing with European statutes, which is kind of sui generis thing, but it's interpretive methods. Can you say anything general about how it might have I don't want to say a unique approach, but a distinctive approach to some of the questions that might be shared by other international courts?
Yes. Let me mention the theoretical logic and an example from our most recent episode. The approach that this court takes is teleological. They are explicitly interested in completing the project of European integration. So they move a lot of questions that were previously thought of as a national issue to a common European framework. Mark interviewed Advocate General Emiliu in an episode that was launched yesterday, and Advocate General Emiliu thought to address the question of Palestinian refugees and the obligations EU member states have towards them now that UNRWA is unable to care for them, given the conflict in Gaza. So these judges take pretty aggressive interpretations of international law obligations of the member states, and in so doing can serve as models that judges can point to on other courts if they are so inclined.
Okay, great. So, but broadly, you started off saying that they had an explicitly teleological approach, with integration being, I guess, the kind of North Star for that. Are they also sort of broadly, generally interested in the project of building international law as a system, or is that a sort of secondary issue? Secondary to EU integration.
Go, Katerina.
So they're often challenging international law as a system. One of their famous cases that readers might be familiar with is the Kadi case, in which the Security Council designation of certain nationals and their blacklisting was seen as incompatible with fundamental European values. Similarly, in the Acmea case, this was seen as a fundamental challenge to the inequities in the investment arbitration system. At the same time, on other environmental issues, they have been very supportive of international negotiations. A famous case concerns airline emissions, their definitions of what territorial jurisdiction would be in furtherance of a global tax system on carbon.
Okay, great. Let's maybe pivot to some of the specific interviews and even just the general project of interviewing. I think thus far some of the things that you've said, one might have come to those conclusions without interviews, just studying cases and kind of the trajectory of various decisions. So what were some of the things that were either most surprising about the interviews, or now that you've done such a large number, I think it sounds like maybe 2/3 of all the judges have been interviewed. Am I right about that?
Yeah.
Yeah. So, that's a pretty good sample. So now that you've done that, what are some of the things that were distinctive that came out of the interview process that one would not find simply reading a case, let's say?
I'll jump in here, Katerina, and I'll say I would put these in, for me, they would fall into two categories. And one would be, you mentioned it already, Cal. Some of these things are likely to seem like inside baseball. But for example, the position of the Advocate General, you may have heard of this. There are members of the court. There are 38 members of the court, of whom 27 are judges and 11 are advocates general. And the advocates general are full members of the court, but unlike the judges who meet in chambers and decide collectively on decisions, the advocates general are tasked, whenever there's a novel question of EU law, of issuing a preliminary opinion, which is designed to help the judges untangle the legal issues. And the advocates general, therefore, have their own voice in a way that's similar to, say, the members of the U.S. Supreme Court, very comfortable sort of speaking publicly about their views. And so I found it, all of the interviews were interesting, but I found talking to the advocates general who are freer, I think, than the other judges to talk about their individual views has been really enlightening. And as Katerina said, some of our most interesting interviews have been with advocates general. More generally, I would say the court. Katerina said it decides about 800 cases a year. That's true. And so the Court of Justice doesn't think of itself as an international court. You asked about specific interviews. We interviewed President Leynertz. Koen Leynertz was our first interview. And he said very specifically, we are not an international court. We are a common court for the member states. We are here to ensure the correct and consistent interpretation of the EU's primary and secondary law and the Charter of Fundamental Rights, which is a huge 20,000 page corpus of law. So they are a common court. They're not an international court. But on the other hand, they're not quite a constitutional court because they decide issues of constitutional significance. And we may want to talk about some of those, but they also decide on lots and lots of more bread and butter issues. So it's a very busy court with a very high workload. In that sense, the Court of Justice is much more like the European Court of Human Rights, with its thousands of cases a year, than it is like the ICJ or any other international court where you have cases measured in the single digits or dozens.
Yeah, that is a really striking difference just in terms of volume. One could also compare the U.S. Supreme Court, where it's also not very large numbers, but maybe a bit more than the ICJ. Katerina, do you want to add any sort of specific surprises?
So something that I think was going to be inside baseball, but now we want to flag, is that every judge, when asked, how did you get selected for the court, said, well, I was nominated by my government, but then I had to pass this incredibly hard test. I was grilled by the Article 255 committee. So we asked a little bit more about what this process was. It turns out about a decade ago, the court set up a system in which it would vet nominees for the bench. So national governments could not propose their cronies or people who were seen as too far right or too far left. This idea, I think, is novel for international organizations, that the organization itself can set up a quality control system well after it is established, and is already being imitated in national judiciaries where the executive wants to take over the appointment of top positions. And their judges associations have formed and say, no, we need a similar vetting procedure so that we can make sure that anyone who goes to the highest level is qualified. Poland doesn't have judges right now for this reason. This committee is a little too scary. It rejects a quarter of state nominees and presumably deters a lot more people from being nominated. So that is an institutional innovation that speaks to the independence and power of the court.
Yeah, that is really interesting. How controversial is that process?
As far as I can tell, it is accepted at this point. So there's a scandal every time there is a rejection, but usually the person who is rejected has something in their resume that is scandal worthy. So the process itself seems to be widely accepted, even as, the court makes headlines when a top judge from some administration doesn't make it.
Yeah, that's striking. So, we only have a few more minutes, but just to go back to something you said earlier, Katerina, about, you mentioned Brexit, and obviously that's an extreme case of, concern with EU overreach or, with the EU project more broadly. And you also mentioned the kind of teleological approach that this court takes, very much focused on EU integration. So I think given, combining those things and combining what you just said about the vetting process and so forth, I'm guessing most of the judges, maybe all of the judges you interviewed, seem to really be EU kind of believers, very much on board with this project. Is that right? Is there kind of fault lines or dissent that you see on this basic question of, should the EU continue to get deeper? Should integration be stronger? How does that all fit in?
I think it is fair to say that all but one judge, and insiders will speak about this judge, are EU believers. At a moment when the European Commission and the European Council are stepping back on some negotiations with the Trump administration, on some concerns about overregulation, the court seems to be pushing forward in the sense that the more formal of the judges take legislative texts and say there's no ambiguity. This is clearly a new right. This is clearly further to EU integration. Other advocates general are open. They say, look, I had a couple of options and I picked the option that would fulfill the project of EU integration. So it is fair to say that at this point, the overwhelming majority of judges are strongly on board with the project.
And is that generally, sorry, Mark, go ahead.
Yeah, no, I would just add to that. I think if you ask the judges, they would say it's not so much that we're pro-European integration, but that and that we do recognize the protected privileges of the member states, but our task is to ensure that EU law is applied uniformly throughout the member states, and so that is our job, and therefore. Any national law has to be in conformity with the basic principles and values of EU legislation. So, for example, you may have heard, Cal, about the rule of law cases with respect to Hungary and Poland, and especially the questions about the judicial independence of the Polish and Hungarian judiciary. And there have been a series of cases in which the court says basically, yes, it is a national prerogative to organize the judiciary as a member state sees fit, but that member states have to comply with the fundamental EU law principle, the treaty-based principle of the independence of the judiciary. And on that basis, the court has found a number of actions taken, especially by the Polish and Hungarian governments, to be contrary to that basic legal principle and found against them. So I would say the thing that surprised me most in these interviews, and the judges are very aware of it, is I tended to think, as someone who studied EU law back in the 90s, that the heroic age of EU constitutional interpretation was back in the 60s and 70s, when the court was declaring the fundamental principles of supremacy and direct effect of EU law. And talking to the judges, they will say, no, we are very much still deciding fundamental constitutional questions within the European legal order. Fundamental questions about fundamental rights, that EU now has its own enforceable Charter of Fundamental Rights. So the Strasbourg Court is not the only court hearing fundamental rights cases anymore. The Court of Justice is increasingly itself a human rights court. And then, of course, it has all the kind of structural constitutional issues about the division of powers between the center, the sort of quasi-federal center in Brussels, and the member states. So I think a while back I would have said that the heroic constitutional age of the court was in the past. And I've come away from these interviews more convinced that these constitutional issues are still very much in play.
That's really interesting. I guess just as a final question, since the Trump administration was mentioned a few minutes ago by Katerina, and just thinking about, one of the things, to step out of the court for a second, that's so striking about Europe today is the fact that Europe is, very engaged, particularly NATO members, of course, but very engaged in kind of rearmament, reconsidering fundamental questions about the international security environment that they live in, fundamental questions about, is NATO a sound treaty body still? Those kinds of things are on the table in a way that were really unimaginable just a few years ago. And Europe is very concerned, obviously varying degrees across Europe, but certain European countries extremely concerned with the threat from Russia and the retreat of the United States. And so it's forced a reckoning with what is Europe supposed to be doing? What is Europe about? Did any of that seem to play into your interviews, or how judges reacted or thought about? Obviously, we're kind of mixing apples and oranges here, but I just wondered how those broader geopolitical trends might influence or have influenced the way the judges think about this broader project of integration.
So one way to think of what a nation state is a state that regulates uniformly, a state that has a big treasury and can finance projects, and a state that has an army. And if you look at the EU treaties, it is really clear that there's a lot of authority for regulation. And until recently, there would be a lot of significant doubts about whether there are provisions for common financing and whether there are provisions for common defense. The national courts and the European Court have already allowed very creative interpretation of the treaties in order to allow for common European debt to go through. So that went through after the COVID transition and after significant challenges in German and other national courts. Right now, the project of the European Commission and the European Council legally is very much to look at the provisions in the treaty that limit how common defense can be and make significant responses to that project. In speaking to a lawyer off the record, actually in a public conference where lots of people were pointing out to problems with prior EU actions that, according to more textualist scholars, required treaty reform, these lawyers said, well, on the one hand, I have the treaty text, and on the other hand, I have Mr. Putin. What would you like me to do? So it seems that there is a way in which the threats Europe faces, both from Russia, but also from the Trump administration and its steps away from the liberal order, might further animate the European integration project, and the lawyers involved seem up for the task.
Really interesting. Okay, well, Mark and Katerina, I really want to thank you for coming on. I hope to have you back. And for listeners who want to hear more, there's so much out there, either on Borderlines, and I assume you guys will be writing this up in some way in the future, whether a book or articles. Is there something in the works?
Yes, absolutely.
Yes.
Okay. Well, stay tuned for that. So thanks, and hope to have you back soon.
Thank you.
Thank you so much.